I'm Suresh Subramani, Executive Vice Chancellor for Academic Affairs at UCSD. It's really my pleasure to welcome you all to this first symposium at UC San Diego on academic freedom. And I do this on behalf both of the administration as well as the Senate. And Senate is represented by Joel Sobel, our Academic Senate Chair. As I'm sure many of you know and recognize, the principles of academic freedom really protect the right and freedom of inquiry and research for the faculty, freedom of teaching, as well as freedom of expression and publication. And protecting academic freedom is absolutely essential to fulfilling UC San Diego's mission to discover knowledge and disseminate this to our students and to society at large. UC San Diego's administrators and the academic leaders share this vision of, with the Academic Senate, a strong commitment and indeed a responsibility to uphold and preserve the principles of academic freedom. But as you'll hear from today's panel discussion, despite or perhaps because the concept of academic freedom is so central to all our things that we do in academia and the things at large, it turns out that there are clear-cut cases as well as gray areas in which I hope our panel discussion today will lead us through, and I think it's good to have this discussion and have everyone think about this more deeply. So we hope that today's symposium will fulfill this particular goal and also give us some food for thought. And I have to apologize to everyone here as well as the committee that we had actually intended this to be a session followed by a series of kind of workshop this afternoon, but given that our chancellor is arriving in a couple of hours, we had to split the two, and we'll do the workshop sometime in the fall. So let me just begin by introducing our distinguished panel. Over on the left is Professor Matt Finken. He holds the Albert Harno and Edward Cleary Chair in Law at the University of Illinois. He's also director of the program in Comparative Labor and Employment Law and Policy, and is at the Center for Advanced Studies. His teaching centers on labor and employment law in domestic and comparative contexts. And last night he regaled us with, along with the other panel members, with wonderful stories and accents and so on. So we hope we'll get a sampling of that. Professor Finken is author and editor, singly or in collaboration, of 9 books, including For the Common Good, Principles of American Academic Freedom. He's also author of a substantial body of periodical writings on labor and employment law, comparative law, and legal issues in higher education. For over 4 decades, Professor Finken has been active in the American Association of University Professors, including service as General Counsel, chair of its Committee A on Academic Freedom and Tenure, and on numerous committees. In addition to his academic work, he's also active as a labor arbitrator. He was elected to the National Academy of Arbitrators and serves on several different standing panels in the public as well as the private sectors. He's a fellow of the College of Labor and Employment Lawyers. So let's please welcome Professor Finken before I go on to the other. Our second panelist, over to my left immediately here, is Anne Franke. She's president and founder of Wise Results LLC at Washington, D.C., and has over 25 years of experience with national trends in academic policy and education law. She's been actively associated with AAUP and currently serves on the panel for the Academic Freedom Fund with AAUP. She consults nationally with colleges and universities on issues ranging from student inquiry to academic freedom issues. She founded Wise Results LLC in 2005 after holding senior management positions at United Educators Insurance as well as the AAUP. Ms. Franke is a fellow of the National Association of College and University Attorneys, a trustee of AAUP's Academic Freedom Fund, as I just mentioned, and a member of the editorial advisory board for Educators' Guide to Controlling Sexual Harassment. So I'd like to welcome Anne Franke here. And finally, Patrick Fox, who's in the middle here, is our final panelist. He's a professor of medical sociology and health policy in the Department of Social and Behavioral Sciences He's also co-director of the Institute of Health and Aging at UC San Francisco. Professor Fox has been a faculty member at UC San Francisco for 22 years and has served twice on the UC San Francisco Divisional Committee on Academic Freedom. He's also served as the UC Committee on Academic Freedom as chair three times and twice as chair. In 2003, he co-chaired the Joint Academic Senate Office and the President's Task Force on Student Academic Freedom, which culminated in 2009 in the addition to APM 10 of a statement of principles, student freedom, and scholarly inquiry. And he's had a long-standing interest in issues of academic freedom as they affect the faculty of University of California. So please join me again in welcoming Patrick Fox to the panel. So we'd like to begin our discussion with a keynote talk by Professor Finken, which will be aimed at distinguishing academic freedom from the First Amendment, both historically in terms of scope and standards of the protection. Ms. Franke and Professor Fox will also have some brief opening comments, which will be followed by a panel discussion that will include some hypothetical cases, and I'm sure Anne will lead you through the cue cards and so on, and so we'll have an interesting engagement of the audience. So, and finally we'll conclude with time for Q&A from the audience so that everyone gets a chance to air their interesting perspective on this important problem. So I'm now going to turn this over to my co-host Joel Sobel, who is Professor of Economics and Chair of the Academic Senate this year, to come up and say a few words. And let me just end, before I turn this over to Joel, by thanking you all for being here. And for those who are going to miss this wonderful occasion, we have this captured on videotape, so hopefully we'll have a chance to revisit this at a more convenient time. So thank you so much. I'll turn this over to Joel.
Good morning and welcome. I shout, doesn't matter. I shout into the mic. You can often measure the importance of the speakers at an event like this by how much time is spent before they actually do their presentation. And I think this is an opportunity to honor them by taking away their time and to give the Academic Senate a chance to take a little bit of credit for this event. So I'm happy to take a little bit of credit for the Senate myself, but I want to say special thanks to our Committee on Academic Freedom and to several folks on campus who I know spent a lot of time arranging this event. Ann Addo, Christy Larson, Diane Heyman in particular. Then I want to try to do one thing. I thought that when I got into this business, I liked the idea of having a job where I didn't have a dress code in which I could wake up in the morning and think about basically what I wanted to, and where my singular lack of respect for authority would not lead to very dangerous things happening. And I have a greater appreciation that I was not fully right and couldn't actually do all three of those things. But I also have a vague understanding that the reason that many of those opportunities are available to me are the topic of today's workshop. Academic freedom, I think, is something that I don't fully understand and take for granted. And I think this is a good opportunity to get educated in a place where people are supposed to get educated. With that, I think the real show should begin. So Matt, I think that you're first up, and I welcome your presentation.
Thank you. Easier for me to stand. Can you hear me?
Yes.
Good. I want to thank Joel and Suresh and Anne and everyone else who's responsible for putting this together. It's timely and an important topic. I did have to ask myself why me, why my ears not watched it. And that's, that I suppose is based on the book I did with Bob Post, who's now at the law school. There is no law in that book, by the way. Called For the Common Good, the Principles of American Academic Freedom. I don't have a copy with me. I'm sorry about that, otherwise I would have cheerfully sign.
Well, we have several.
Oh, wow. You know, Yale's a great publisher. They really know how to publish books. They don't know how to market them. That's a familiar frame in this room. So why did we do the book? We did the book because, precisely for the reason that academic freedom was a hard-fought battle at the turn of the last century, the 20th century. It has a contour, it has shape, it has meaning. It has become so widely accepted institutionally and by faculty that it's really lost the understanding of the centrality of its core. It's become, quite frankly, a kind of shibboleth. Faculty say, faced with all kinds of demands, some legitimate, some illegitimate, oh, that infringes my academic freedom. Not only here, but in Germany as well. I do some work in Germany, and you know, one hears the phrase akademische Freiheit bandied about with a similar looseness. So we thought we would go back to basics. The book really is an explanation and defense of the American principles. And I'll stress American because there are other systems. The Brits have a very different view. It's much more akin to really free speech and the degree of eccentricity your colleagues are willing to tolerate. Canada seems to be looking for a theory, and the French are lament, but the French lament pretty much everything. What I want to do is explicate a little bit of the profession's theory of academic freedom and compare that to the developed texture of law under the First Amendment. I've got about half an hour, and then we can have some questions or just move on to the panel. There is none of the First Amendment stuff in the book. It's strictly an historical development and explication. Now, I want to stress it is the profession's theory that I'm talking about. It's not Finken's theory or Post's theory or Frankie's theory. I debated a generation ago, and he's still around, I debated Mark Udall when he was dean of the University of Texas Law School on academic freedom. And my particular cut at that time was a discussion of the rights of faculty as citizens of their institutions, what we call in AUP parlance intramural speech. And Udall was quite acerbic. Perhaps I don't think that's characteristic of him. Calling it Finken's theory. Right. Well, why should professors be able to criticize when workmen do not, for example? And the example he gave were painters. I'm walking through the halls of the University of Texas Law School. He was then dean, and painters are grumbling that the fact that they are required to use rollers rather than brushes. And don't they have a similar professionally based claim? Why are professors any different? To denigrate the idea of Finken's theory of freedom of intramural expression. I made that point only because it wasn't my theory. It's the profession's theory. It's based on the documents and reports that have been generated for the previous century. Now, you may criticize it, and it's a valid ground of criticism. We can proceed on that basis, but it is the profession's theory that Post and I expound. And in fact, that points, we indicate where we think the area is under-theorized or needs further development, or quite frankly, is troublesome. And by the way, just as a footnote, Udall shouldn't have picked that particular example because at the turn of the 20th century, there was a struggle in, I'm wearing my hat as labor lawyer, labor historians of those, struggle over who controls the means and processes of production. And indeed, there was an enormous protest in New York by painters who rejected using rollers in favor of brushes, because this was painters' work for them to decide, not for the bosses, to decide how they will do that work. It was a similar occupational claim. And the fact that they made that claim, grounded in their notion of their own sense of collectivity, of manhood, how you will, autonomy, is not purchased at the cost of anybody else making a different claim, differently grounded as professors did. So let me go back to 1915. When the seminal document, the 1915 Declaration of Principles on Academic Freedom and Tenure, was promulgated, founding document of the AUP, drafted by a group of luminaries looking back on it, primarily Arthur Lovejoy, but for those who are in law, Roscoe Pound has some in it, or Richard Ely. This was an upstart group at the cutting wave of attempting to professionalize the American academic profession, as it had not been there before. Borrowing on the German model, creating an authentic American university, resonating against the old college, which was primarily denominational, staffed by clerics, producing, teaching more for the development of character, and so on. These histories are really very well known. And it's a ringing document, and the document made a claim for academic freedom, modeled very largely on the German model, but it changes in translation. In good measure because the difference in governance of the institutions. German universities were self-governing, largely self-governing, although financed by the state. They didn't have an office of president. They didn't have trustees. How do you translate the model of where the faculty are cherished as relatively high civil servants, nevertheless owing an obligation to the state, to the American scene? 1915 Declaration spoke in terms of freedom of the character of the American university, of its function. They used a very progressive, right? This is after all 1915, very progressive trope of the university being a kind of intellectual experiment station. Where new ideas may germinate, and if they're distasteful, we'll spit them out. If they bear fruit, so much the better for us. The role of research which had to be unfettered in order to benefit the public good, and teaching, the dissemination, the testing of knowledge, and the instilling in young minds of a respect for scholarship and freedom of thought. All of this to be held to account by a professional standard of care. That was the trade-off. So long as the speech was conducted in a scholarly spirit and in a scholarly manner, it was a scholar's freedom. Spinning off that, they dealt with the role of the faculty in the institution. This is a time when employees were employed at will, where we had an increasingly divided class structure. And the document's remarkable. And if you read the language surrounding it, the polemics in the progressive press, professors were not to be hirelings. That's John Dewey's phrase. We're not mere employees. They stood on the status of equal honor with the trustees. They weren't just not disposable hirelings. So there's a claim for, in the document, for the role of faculty, qua faculty, in the life of the institution, of a stature equal to and independent of the trustees. For example, the claim for tenure, it is unbecoming any profession that the profession should not judge the quality of those who are to be retained. In other words, going to dismiss a professor, it is the peer group that should make that decision on the basis of the hearing, not by the employing regent. The least well-developed notion in that document is the idea of political speech, public utterance. But I'm not going to spin it out any further than that, except to say that what we take to be the four facets of academic freedom, which is freedom of research and publication, freedom in the classroom, freedom of teaching and dissemination, wider dissemination, freedom as a citizen within the institution to address all manner of institutional policy and decisions, and freedom of public political discourse, all subsumed under the umbrella of academic freedom, each subject, however, to its own separately cabined standard of care. Put that aside, and let's turn to the First Amendment. In 1915, when these claims were by an upstart profession, were being asserted in the face of assumed regental authority, what was the law of free speech in the public sector? The First Amendment, most law students are not, when you say, well, you work for GM, can they fire you because you're Jewish or Catholic or you're a socialist? And the answer is, no, they can't do that. That violates what? Your First Amendment rights. Well, no, it doesn't. Law students, let alone the citizenry at large. You hear this as ordinary discourse. It violates my First Amendment. First Amendment says Congress will make no law. Congress will make no law, not General Motors. Founding fathers, or Warren Harding's phrase, were not fearful of private centers of power. They were fearful of government. Government may not restrain your rights of speech. It's nothing about private centers of power. That's true today. So what I'm talking about only applies to public institutions of higher education. In 1915, in fact, the universe of higher education was dominated by private institutions, most of them small in denomination. The First Amendment had no purchase in any event, and does not have purchase today at places like Northwestern or the University of Chicago. What was the status of the free speech rights of a public employee in 1915? It was governed by, captured by Oliver Wendell Holmes Jr.'s famous aphorism as a justice of the Supreme Court of Massachusetts, 1892, city of Bedford, where he said, you know, Holmes was a master of aphorisms. He wrote aphoristically, and when his aphorisms were right, they were wonderful. Just wonderful. But when they were wrong, they condemned our law for a century. 3 generations of idiots are enough. That was Holmes sustaining a sterilization law. Petitioner has every right to talk politics. He has no right to be a policeman. City of Bedford. Can you fire a policeman for circulating a political petition? The answer is yes. He has every right to talk politics. He has no right to be a policeman. Holding a public job is it's a privilege. The Constitution simply does not apply. If you want a better case, I will give you one involving a school teacher in Tennessee. Actually, Tennessee's passed that because we were coming back to it. It's a new law because, John Scopes was convicted of the crime of adverting to the propriety of the doctrine of man was descended from a different order of animal. And his conviction was sustained by the Supreme Court of Tennessee in 1928 in language that went like this. The statute is an order by a master to his servant, to its servant, the state, the schools, as to what work that servant will, or more accurately, will not do. Namely, don't teach evolution. In doing so, the state is unhampered by the constraints of the 14th Amendment. Unhampered, unfettered. The Constitution doesn't apply. So, when the drafters of the 1915 Declaration were asserting for professors certain rights of freedom of inquiry, freedom of teaching, and so on, it was against a background where, first of all, employees were considered a lower order of being in an emerging great class society. And secondly, public employees had no rights at all. Mere privilege. All that changed, well, we thought it changed, in 1967, when the Pickering case was decided. I was in law school. Martin Pickering was a school teacher in a high school not far from where I currently live. Wrote a letter to the editor condemning the school board for its profligacy with respect to a bond issue, and was promptly dismissed for it, on grounds of a breach of duty of loyalty. An employee owes duty of loyalty not to criticize his or her employer. By the way, that's still the law today. Goes up to the U.S. Supreme Court. The Supreme Court says, well, when speaking on a matter of public concern, upon which there was no showing of any disruptive effect on the school board at all, and as to a matter that was not within Marvin Pickering's particular expertise, you'll notice that the free speech, First Amendment applies. Now, many of us in our youth and salad days hailed Pickering as a landmark decision, not looking at all the landmarks the court had planted, knowingly or otherwise. And I tend to think otherwise. I was a Thurgood Marshall. What? And the trajectory of free speech of public employees has come almost, but not quite full circle. In case of Connick versus Myers, 1983, that's 1967. Sheila Myers was unhappy at her assignment or her lack of being promoted as an assistant district attorney in the city of New Orleans, and circulated a questionnaire among her co-workers. How do you think things are around here? To her superiors, she was fomenting a mini insurrection. And she was fired for it. Did this violate her First Amendment rights of free speech? The Supreme Court said no. She was not raising any matter of public concern other than the generalized interest in the efficient management of the district attorney's office, and we all share that in general, and that's not a specific concern, inadequately specific concern. They distinguished the private gripe from speech that addresses an economic, social, or political question of moment to the citizenry at large. Already, the court starts cabining zones of speech. And with respect to the one question that could be understood, which had to do with a degree of favoritism within the office, which could be understood arguendo, for the sake of argument, as raising a First Amendment concern, she disrupted the office. And disruption trumps. Then in Warden versus Churchill a few years later, the court says, well, you don't have to show actual disruption. It is a reasonable fear of disruption. So even though what you're saying is free speech, it contributes to the robust argument in the political forum if your superiors or co-workers or other stakeholders are sufficiently disturbed. They have a veto right. Now, if you think that I'm making this up, as Anna Russell said, right? I didn't make this up. There is a case in the Second Circuit in New York with a school teacher at the Bronx High School of Science who had taught there for over 20 years. Much beloved. Those of you of my generation think of Wally Cox, right? Armis Brooks. But it turns out that he was the secretary of the chapter of the Man-Boy Love Association. NAMBLA. And, always happens in these cases, a local TV station picks it up and runs a story. He edits the newsletter anonymously. All hell breaks loose. Bronx Science. He's been there 22 years. There's never an allegation of any act of sexual harassment, pedophilia, or the like. Never. Are the expressed concerns of the parents, their threats to pull their children out of Bronx Science, enough to warrant his dismissal for engaging in otherwise constitutionally protected association of speech? And the Court of Appeals of the Second Circuit says, obviously, yes. Now, the famous Garcetti case, where an assistant district attorney is protesting, as I read it, that a defendant was being railroaded with respect to a search warrant, and informs a defense to that effect. And this is a case of lèse-majesté. And the assistant district attorney is this one, goes to the U.S. Supreme Court. Supreme Court says, wait a minute. We're talking, Pickering covers speech as a citizen, of course, on a matter of public concern, economic, social, political concern to the community at large. He wasn't, this assistant district attorney wasn't speaking as a citizen, he was speaking as assistant district attorney. That was part of his official duty. That's not covered by the First Amendment at all. It's simply not free speech. It's subordination. Now, a case that adumbrates, I think, where the court went. By the way, Justice Souter has some language in his opinion, says, well, where does this leave college and university professors? And the court says, well, we're not addressing that. We're not addressing publication and classroom teaching. We're very careful about what they said it doesn't address, leaving open the whole question of governance, of intramural speech. Extramural speech would still be covered by Pickering to the extent, however, there is no heckler's veto, to the extent that your co-workers are not sufficiently disturbed as to want to squelch what you say. There's a case I rather like in Indiana, which was a teacher who was teaching the prescribed curriculum for middle school students about language appreciation. Right? There are other languages in the world. That's a quote from a case which said the teacher is allowed to tell the students there are other languages in the world. I don't know that that's true anymore. I know. In this case, the student wrote, the teacher wrote the word white on blackboard, and then in Spanish, white, blanco. And then black in English, and in Spanish, negro. Well, his parents complained, you can't write negro on the blackboard. He said, I was writing the Spanish word for black in a language course, which is part of the curriculum. Well, I don't care what I told you to do, you can't do it, and you're being disciplined. And that teacher lost the case on First Amendment ground. This is before Garcia. Today, I think that teacher could have no purchase in court at all. Can the school board say you are not to tell your students that there are other languages in the world? I think the answer to that is yes, at least not in terms of any protection, any insulation one can claim for the First Amendment. That's the First Amendment. Now, what are the differences between academic freedom? Let me give you two and the first one. Let's just take a professor of Middle Eastern Studies who says to her class, on thoughtful reflection of the trajectory of events 1948 to the present, I believe the best solution to the Palestine-Israeli situation is for there to be a single, unitary, secular state. You and I think, all know that all hell would break loose. Was the utterance germane to the class? Yes, of course, in Middle East studies. Did the statement reflect an honest judgment on the basis of professionally understood criteria or standard of care? I think the answer is yes. Could that professor or instructor be sanctioned for it? I think the answer to that is no. That's what academic freedom is all about. Now, to the extent the proposition is one that is controverted within the discipline, the teacher may not require the students to agree with her proposition. That would be indoctrination. David Horowitz. That is where the line is drawn. It is one thing to say 2 and 2 do make 4, unless you can persuade me on the basis of valid arithmetical theory, but that's not correct. It is quite, I was a student, my undergraduate degree is in geology. And I worked at the Lamont Geological Observatory in 1966, and a hot debate in that period, those of you who go back then, and geologists in the audience, was plate tectonics. Now, some geologists thought that plate tectonics made a lot of sense. A lot of them didn't. I was taught by an anti. And no less a figure than Maurice Ewing, the director of the Lamont Geological Observatory, thought the word he used was rubbish. The theory was rubbish. Now, could he tell his students, I think this theory is rubbish? The answer is yes. He had all kinds of geophysical data which said that the Earth doesn't move side to side, moves up and down. Could he put it on a multiple choice test? You know, or an essay question? Give me the 7 reasons why plate tectonics are wrong. No, because it was a controverted proposition within the discipline. It's not controverted now. I think now if a student said I'm an anti-plate tectonic believer, I think you shouldn't get an F. And rightly so, because the profession has achieved a consensus of correctness on that. By the way, this is a footnote. What happened? 3 of Ewing's graduate students, and I knew them, came up with an elegant experiment. I mean, elegant. And there were the data, and he looked at it literally overnight. God damn it, he was wrong. They were right. And he just changed his mind. Let's assume a groundskeeper, my final point, a groundskeeper of the University of California, Santa Barbara. I assume you have a zone, which is public thruway, which is a zone for free speech, puts a soapbox and invades against the treatment of Native Americans, hands of the American government and army, and points out that in 1877, or whatever the date is, in the far west, the army handed out blankets infected with smallpox and wiped out local tribes. Just one of the series of incidents of a disastrous American Indian policy. Can you sanction that groundskeeper for that? I think not. The groundskeeper is addressing a matter of concern, historical concern, current concern. Did that incident happen? No. But under the First Amendment, speech is disallowed as sanctioned only if the speaker knew it was false or spoke with reckless or wanton disregard of the truth or falsity, which means had reason to believe it was false at the time it was done. I have no reason. He deeply held. It was the oral tradition of the family. Right? His great-grandparents told him about it. That's fine. What if you are a professor of American Indian Studies? Sounds like the word Churchill did. Yes. And you say, and you're right, and you teach, that this event happened. Well, what's the evidence for? Well, 2 articles cite to this event. In the actual Ward Churchill case, both of those articles were written by Ward Churchill under a pseudonym. In turn, they cited no other evidence. But he cites his 2 ghost-written articles as evidence for a proposition that the hearing committee concluded was fabricated. No. It may be as a matter of robust political debate, you're free to fabricate. Our political life would be rather impoverished. A professor may not. That is an abuse of that. It is not protected by academic freedom. It's an abuse of standards of professional behavior. That's the difference. Academic freedom is at once more circumscribed, but more absolute than is free speech under the First Amendment. Academic freedom did not derive from the First Amendment, was not derived from the First Amendment, wasn't derived from the law of free speech circa 1915, which didn't exist. It has its own history, its own logic. And that's what I think we ought to be concerned about. And I'm saying this, I guess, as a declaration against professional interest as a lawyer. To hell with the law. Or what the courts do. That's not our concern. As academics, we have to be concerned about what the academic proprieties are with respect to speech that falls under one of those 4 heads. Now, they're not without difficulty. It's not without difficulty. How much one is prepared to license in the public arena, and to what extent is that excess of zeal and rhetoric? To what extent does it permit inquiry into whether a similar lassitude toward the evidence is manifested in the individual's own professional work? May or may not be. May the inquiry even be made? That was one of the arguments in the Ward Churchill case. But for his calling the victims of 9/11 little Eichmanns, for which he was not sanctioned, but he was investigated in terms of whether his own professional publications showed a similar indifference to reality, and it turns out it did. Some have argued that the connection is such that the inquiry was impermissible, should never have been made. And that's something we might profit from talking about. I've struggled with that as an arbitrator, where an inquiry is made about an employee for invidious reasons, but if it turns out the employee is discovered to have engaged in serious misconduct. Are we to blink at the misconduct because the initiation of it was wrongful? What if the inquiry discovers that their credentials were forged? Should it make a difference whether you're a doctor or an academic? Any of that. These are the kinds of nuances and sometimes difficulties that emerge within the confines of the doctrine of academic freedom. That's fine. You may find degrees of incoherence in the doctrine itself. My purpose here today is less to explicate the doctrine, the application of the doctrine we'll get into in case studies, than to try to make a sharp distinction as to why academic freedom does not derive from the First Amendment and shouldn't be looked to the First Amendment as a source of inspiration. Thank you. We've caucused. The bargaining committee thinks that we can take some questions now as a lead into the remainder of the panel discussion and further Q&A after that. So, yeah.
I work in the contracts office here at UCSD, and the things that I face with the contracts that I deal with and the professors that want to publish the research results, at times the government will attempt to have the right to tell us when we can or cannot publish because of national security or sensitive information that may be not classified. Do you have any advice on how to deal with something like that? We have a policy here and in the University of California system that the academics do have freedom to publish, and we cannot restrain it in any way in our contracts.
And has actually dealt with some of those, hasn't it? It's a very tough problem. It's a very tough problem because when the 1915 declaration, and it's a ringing declaration about the role of research, this is before World War I, and before we realized that research can have negative. And we saw it recently on the flap about publishing the modified avian, was it not an avian flu? Or, yeah. There are a couple of AUP reports, Academic Freedom and National Security. I was on that committee, along with the president of one of the biochemical, Jim Atlas. I think what they do in terms of the journals, and it came up in that episode that are you publishing a manual of mass destruction? Right? Is that, if so, right? I mean, I do think that we do recognize limits. Now, having said that, the history of the suppression of scientific information in the name of national security is a sorry one. It's very easy to take a stand. Or in these days of corporate research, where the sponsor wants to retain the proprietary nature of the information. I mean, that to me is an easier one. I don't think no university should permit. Universities exist for the dissemination of knowledge. It's oxymoronic to say that we're going to permit research to be conducted, and a corporate sponsor can have a veto. Now, it's not to say that there may not be reasonable limits of time. I think there's a new report coming out, AUP's produced this very large report. It's over 100 pages on aspects of the problem with respect to corporate research. With respect to national security, I think we have a better handle, simply experientially, on what the limits are. But limits there are. Many institutions, I don't know the situation here. I do know MIT, for example. Lincoln Labs is not MIT. So if you're going to do classified research, that's done in an entity that's not the university. The university itself will not sponsor classified research. But, ladies and gentlemen, sometimes, and I said, there can be, I worked on a problem at the University of Pennsylvania, had HUD money, before it was HUD, housing redevelopment money, looking at areas for urban renewal. Could there be a restriction? Could government impose a restriction on disclosure of the research? Well, the answer was if it was known immediately that these are the neighborhoods that they were studying, you would invite speculators to tip the neighborhood, drive the, and take advantage of sort of insider information on trading. So that was, in fact, classified information. Not in the name of national security, but for obvious other reasons. Was it impermissible for Penn to say, well, for a year, whatever the period was, 6 months, we can't publish the results because of the communal consequences? I don't think that's I mean, there are certain reasonable balances that simply have to be struck.
Just as a follow-up too, the freedom to publish. It seems to me that faculty, if they want to take on research, and the government says, well, here's a bunch of money and here's some research I would like to have done, but you can't publish it unless we say that you can. Academic freedom, can the professor, why cannot the professor then say, okay, I won't publish it, I don't need it for my academic advancement, I'm not going to have any students.
Because it introduces the nature of the institution.
However, there was, a number of years ago, a couple of cases of this example that came before the University Committee on Academic Freedom. One of them was in the wake of 9/11. The federal government was proposing to promulgate contract language which gave them the power to retroactively say to targeted people who were doing research on viruses and other things that could be used as weapons, really, to say, we'll give you the money, but the proviso is that we may at some time not allow you to publish your findings because we may student's career is shot because they can't publish their dissertation research. Another example is that the national lab staff wanted to be part of the faculty. And this wasn't possible because they could not publish the work that they were doing from the standpoint of national security. So those threats happen periodically, and they don't happen that often, but there are examples of that. On my own campus, a professor did a clinical trial under the auspice of a drug company, and she signed an agreement, and it didn't go through contracts and grants. And in the agreement, the drug company said that, you know, we have the power to determine whether these things will be published results. Well, the drug that was tested was no more efficacious than drugs that were already on the market. At the university, even though the faculty member didn't do right by not sending it to contracts and grants, but they didn't have a right to publish it, and the article wasn't ultimately published. But those things do happen periodically. And it's a very important component that contracts and grants function to ensure that these freedoms are in the context of the agreements that faculty have with outside external funding agencies. So it's a very important function of contract.
And let me just highlight the gray area in this before. I think we had a second question in the back. To me, if the grantor, be it the government or a private entity, is saying, we will decide when you can publish, that there's this vague, unending, possibility of no publication, my suggestion to the university would be to reject that condition. If the grantor is saying, hold publication for 2 months, that may be something the university would regard as a de minimis infringement on the right to publish. And so there is that gray area between we will tell you when you can publish and a short delay. And I think it's incumbent upon the institution to decide how much is too much within that gray area. So to me, there is no one formula other than do not buy into the delegating to others the decision on publishing. And so it is a sliding scale. When does the infringement begin? Long ago, I worked on a project involving how long the Postal Service could divert one's mail while they were doing an investigation, and there was a law that said 3 days. And the thought in the civil liberties community was, okay, we can live with that because that's sort of within the margin of when your mail might be delivered or not. And I'm sure that post 9/11, this government right to retain our mail is significantly expanded, but it's the same kind of sliding scale. And there was a hand up in the back.
My question is, since you have shown rather nicely that academic freedom is not dependent upon any constitutional privilege, the question I would like to ask is it going to differ by state?
So I'll take a shot. But, it is up to, as a practical, I mean, then what is the source there in terms of legal protection? The source becomes a matter of institutional policy. Each institution is free to fashion its own policies. Now, I would argue that most institutions' policies provide for academic freedom. Most give a Delphic or even less helpful definition of it. And that doesn't trouble me at all, because the argument of the book is that the phrase has a historical depth and meaning. That when you use the phrase academic freedom, this is what it means. It is almost a term of art. If I order a baker's dozen of cupcakes, right, that's 13, not 12. Because that is the custom or the usage of that trade or profession. The remarkable achievement of the AUP for the past 100 years has been exactly that, to give content to define by policy pronouncement and by case-by-case investigation and explication what the contours of the doctrine are. And so when an institution says, we accept academic freedom, it is the academic freedom that everybody else accepts. It is a remarkable achievement that academic freedom does not mean one thing in Missouri and something else in California, one thing at the University of Illinois, and something else at the University of Massachusetts Amherst. It has not been balkanized. It has been a unifying element in the history of American higher education. Now, having said that, is it possible for an institution to deviate, to say, well, what, you know, as some religious institutions do? Well, we have our version, which isn't your secular version. And they do that. And is their version as a legal matter what is the accepted norm, or binding, legally binding norm on that institution's campus? The answer is yes. It does not mean, however, that the profession, to the extent it plays out in inimical ways, is not perfectly free to condemn the institution for its deviation. So I would argue very strongly that we need a unifying, singular concept. The profession is mobile. People come to University of California, they go to Illinois or MIT. Their understanding of academic freedom should not vary according to the institution that houses them at that particular moment.
I would add a footnote to that there can be state laws that bear on academic freedom. For example, in California, there's something called the Leonard Law that requires private universities to give their students the equivalent of First Amendment protection. And so that would, in effect, be an enhancement of the rights of students in California's private institutions, because this whole you have the right to say what you want, but you don't have the right to be a policeman, is not a body of law that applies to students. Similarly, there's been debate and struggle in the law over subpoenas for journalist sources and subpoenas for scholarly research. And here I'm talking about a scholar who is not volunteered as an expert witness in a case, but who happens to be doing research on a drug, on an injury problem, on Jeep rollovers, that happens to be the subject of litigation between other people. There's a question about whether the parties to that lawsuit can reach out to the professor and say, bring all your research into court. We want to look at it. There are some states that are passing statutes that protect journalists, and there are also some states that are protecting researchers from that kind of third-party intrusion into their research. So that's a matter of state law and an issue where the freedoms of researchers may vary state by state. And I believe Matt spoke about the Garcetti versus Ceballos case in the Supreme Court. There are public institutions that, on their own initiative, are saying, we will give our faculty more. We will give back what the Supreme Court may have taken away from faculty in Garcetti. And I believe that there may be some state legislatures that are considering the same kind of global fix to the Garcetti principles. I think that these variations among states and in state statutes are grounded in precisely the professional principles that Matt was suggesting are and should be national policies. So there are some state legislatures that have been more sympathetic themselves to that professional standard.
Speaking of, there may be idiosyncratic domestic deviations that potentially threaten academic freedom. Freedom of Government and Sunshine Acts, or Freedom of Information Acts, which apply only to public records. In some states, there's been litigation of claims made for email records of faculty members. And this some states insulate expressly faculty records from that kind of public exposure. Others do not. And that's a genuine concern. I think Illinois does not, and I will take care of that when I get home. Well, we have a Democratic legislature, a Democratic governor, and we can get anything through as long as it doesn't drive our deficit up. But the Garcetti-Ceballos problem is one that is easily remedied by a change of institutional policy, by correction to institutional policy to make sure that when a faculty member speaks, irrespective of the hat that faculty member is wearing, to address any matter of institutional decision or policy, that is protected under the rubric of academic freedom. We have such a policy been drafted in Illinois. It's now, I hope, after 4 years of drafting, it's before our Board of Trustees. I think one is in the California system, is it not?
Yes, yes, right.
Yeah, and I would hope it goes through, because absent that protection, you have none at all. You see? It really turns upon how the institutional policy is drafted.
And let me add one comment about the different application of state open meetings and open records acts, and then perhaps we'll turn to Pat for his comments on Matt's remarks and some system perspective. Freedom of Information Acts in the states do vary dramatically. People often look to Florida as having the most open, the most sunshine down there in the Sunshine State. Well, from an academic perspective, I think Alaska trumps. Alaska has more sunshine in that their Open Meetings Act has been construed by the courts to apply to faculty committee meetings deliberating on the tenure candidacy of a faculty member. With the consent of the faculty member, those can be open meetings. Pretty dramatic. So, Pat.
So just to go back to the Garcetti case and some of the points that have been made, there is in fact proposed modifications to the APM 010, the University Statement on Academic Freedom, to allow explicitly faculty to make comments about in their role as joint governance representatives of the university to criticize the university administration's policy. Now that came to the University Committee on Academic Freedom as a result of a case that is still is in the courts right now by a faculty member at UC Irvine, who was critical of his department for hiring part-time adjunct faculty to do teaching, as opposed to having the regular ladder-rank faculty. He was denied a promotion, and he claims that the reason he was denied a promotion was because he spoke out against the policy of the administration of his campus that were using part-time employees. And on the University Committee on Academic Freedom, we heard the case, and General Counsel came to us and said, we've actually advised the administrators on that campus to invoke the Garcetti case in their defense. And we on Academic Freedom thought that was, well, we told General Counsel we thought that was a bad idea. But anyway, that led to thinking about this particular issue because there are other cases, as Matt has described, that were, more problematic. And so it is winging its way through the system. I think it's already come to the divisions for review, and there were some modifications suggested. So that process is winging its way through. But at the same time, General Counsel told us that, generally speaking, if the university has an explicit policy about those types of things, it's going to protect the faculty much more than not having a policy, because then they'll recur to the court decisions. And generally speaking, I don't know, Matt or Ann, if you would agree with this, but generally speaking, that was the opinion of the General Counsel, that if we have it in our policy, then we are much more protected, because the courts are not going to necessarily want to go into that and say, well, you can't do that. It's part of the policy. So that's an important thing that's happening now, and I think it's going to be something that's very timely and important, especially as we're under with the Great Recession, we're under increasing fiscal constraint, and changes are happening on our campuses. And I think that I would be happy, if you put it that way, to have this modification of APM 010 in there, so faculty can feel more free to speak out against institutional policies that they may disagree with. The other comment I'd like to make, which I think is more of a conceptual or theoretically problematic area that may occur, again, as our campuses are having fewer and fewer resources from the state, and I've seen it around your campus, and the same thing's happening on my campus, much more encouragement of the integration of the academy with private sector businesses. Now, inherently, you would think that a private company who is interested in developing a product and marketing that product wants to not let competitors know about the kinds of research that they're doing, because they want to own whatever is generated. And I thought that there are maybe potential issues that might arise. I know that each campus has conflict of interest policies and things like that, but as economic situations get more dire and there's more desire to access funds from other sources than the traditional ones that supported our campuses, I think it's an area just to be aware of, and for us as faculty members to kind of think about it from the standpoint of the academic freedom, the openness that we've been discussing about, the publication of research, the free exchange of ideas and things like that, versus commercial privatization of these things, which is not necessarily designed under those types of principles. So anyway, those are some of the comments that I had from what Matt was talking about, as well as some of the conversations and questions that people had today.
Did you want to talk a bit about the process within the system and the campuses? And you have some materials, I think, also.
Right. It was interesting last night when we were having dinner, and I was mentioning to Matt and Ann that in our system, committees on academic freedom don't deal with individual cases of faculty lodging a grievance against the campus or the administration about breaches of academic freedom, and Matt thought that was kind of weird. But I know that from an example of a case that occurred at UC Santa Barbara, where a professor was being investigated around what he presented to students in class. He was pounding on this committee on academic freedom on the campus, said, who's going to defend my academic freedom in this case? And it got a lot of press, and the UP wrote a letter to the chancellor at that campus saying, you know, what you're doing to this professor is problematic, etc. And finally it came to me, because at the time I was the chair of the University Committee on Academic Freedom, and he was saying, you know, what kind of help can you give me? And it was just a matter of saying, well, you need to go to your Committee on Privilege and Tenure on your division, because your divisional Committee on Academic Freedom, as well as the system-wide, does not deal with individual cases. Our charge is to deal with the institutional problems which may threaten academic freedom, either internal or external. And once, you know, I communicated with him and he understood that, then the situation got resolved rather quickly. But that was something that it looks on the face of it that, well, I would go to my Committee on Academic Freedom if I have a concern that my academic freedom is being abridged. But just go to your Committee on Privilege and Tenure. I've got a little outline here of some of the relevant sections of the APM, which kind of govern these things. So if anybody's interested in it, you're welcome to have a copy of it, just for your own information.
Pat, would you say go to both committees so that there's somebody looking at the policy perspective as well as someone looking at the individual situation?
Yeah, I think it depends on what the situation is.
Okay.
Because there was a case on my campus where a faculty member had to go through not only human subjects for his research, but in the cancer center, the protocol review committee. And he felt that he was being unfairly critiqued by the protocol review committee. So for example, the study was to test some intervention for cancer treatment. And one of the faculty members that was on the research team was an anthropologist. And the anthropologist was going to collect qualitative data on the patient's experience of this treatment. And one of the biostatisticians on the committee said, "What kind of methods are these? This is like European research." and the ironic thing is that the grant was funded by the NIH, and the investigator had the funding, and he had to go through this whole process of rationalizing why they're using an anthropologist, et cetera, et cetera. So he came to our committee and said, "I think there's something wrong with the protocol review committee." So there's an example of a possible institutional problem which we had the power and did investigate. And so you're right. And sometimes it can come to you, to your divisional committee on academic freedom, especially if you feel that there is a systematic problem with either the way your institution is operating in some of its, let's say, review mechanisms like for human subjects. There was also a case that was kind of interesting because it was one of the senators from your area who did, you mentioned Horowitz, the Students for Academic Freedom, had introduced legislation twice to define academic freedom and to have specific oversight of social science faculty in terms of what they teach and how they teach it and how they're evaluated. And it didn't go anywhere, thank God, but it was another example of an external threat to academic freedom, which we tried to keep on top of and really, argue against. And also the president did a good job on that, so it didn't go anywhere. But those are just some of the examples of how your divisional committee can operate in terms of internal and external threats and differentiating them from an individual case where a faculty member feels that their privilege under terms of academic freedom is being threatened or has been abridged.
And I'll take the floor now for a moment and tell you some about the handouts and also preface that with a little bit of a wider perspective. Fortunately, we are mostly beyond the political period that lasted 8 or 10 years where there were these calls for balance in teaching and efforts to introduce state legislation and indeed some legislative committees in states that were considering laws captioned as advancing academic freedom because they would require balance in the classroom and balance in faculty hiring. Missing the fact that whose idea of balance is it, and if you're teaching Shakespeare, what counts as balance to Shakespeare? So it was an unworkable system that fortunately did not progress beyond the committee stage in several state legislatures. That leads me to the context of raising awareness of what else is going on beyond a campus community. And within a campus, there can certainly be debates in this kind of forum and progress made on academic freedom issues. I have a confession. I snuck into an academic meeting in January. Now, most people run screaming from academic meetings, but the Law Professors Association was meeting in Washington, and there was one panel I wanted to hear very much, but I didn't want to pay hundreds of dollars, so I snuck in to hear their panel on international academic freedom issues. And there, one speaker was making the point that only in the US is academic freedom discussed as that phrase. Everywhere else in the world, the concept is academic freedom and responsibility. And I wonder myself whether there might be more public acceptance of faculty discourse, of the concerns of universities, if that pairing were to become more common here, because absolutely there are professional responsibilities enforced by the profession. That's why we have peer hearings on faculty dismissal, for example. We have ethics statements. And so to couple those concepts, I think, can have some salutary effects as the wider community looks at universities. Another thing I picked up from my sneaking into this hotel meeting room in January was a new appreciation for a group based at New York University called Scholars at Risk. They look to academic freedom issues experienced worldwide where there are people in fear of their lives and their livelihoods for the content of their teaching and research. And so they intervene in these situations. And one thing that they do is bring scholars to the US and place them at a network of institutions that works with the Scholars at Risk group for a year or two, study project or, some kind of academic support for that individual. And therefore, it came as no great surprise to me when the blind Chinese lawyer who escaped from his home detention was offered an opportunity to come to New York University. It just struck me, that's a very natural pairing. So I bring to you the concerns of the wider world in terms of threats to academic freedom. And also in the wider world, I would include your state, your community, other colleges, the K through 12 context. Would a teacher here in a high school be at risk for writing negra on the blackboard? I was doing some news searching on academic freedom about a year ago and found there was a community college, unfortunately I don't know which one, in California, where a trustee was suggesting that the college should no longer teach Arabic. And it wasn't a budgetary issue, it was a political issue. And fortunately, they had a community dialogue and other trustees prevailed in rejecting this misguided attempt to control the curriculum. I have set up a Google News alert on academic freedom, and those of you who care about this issue may want to do something similar. You could do a Google News alert on academic freedom California, and that would bring you threats from the public schools, threats from other public and private colleges, graduate schools, community colleges, and you might find occasions where you can use your secure platform here, your tenure, your long-standing relationship with the university to express these professional values in other settings where those expressions may be very helpful to those whose academic freedom is threatened. So again, I give you the context of both the wider world and your own wider community. Now, each of you, I think, received a copy of this primer on academic freedom. I co-authored this last year with a wonderful man named Robert O'Neill, who, like Matt, is a former general counsel of the AAUP and former chair of the Committee A on Academic Freedom and Tenure. He's also a former president of the University of Virginia and a former president of the chancellor of the University of Wisconsin system. And this was an effort to really provide a primer, as it's titled, to both academics who may have passing acquaintance but want more detail, and then for the benefit of trustees, administrators, and even the public who would be interested in this information. There was a printer's error which put Frederick P. Schaefer's name on the front of the primer, even though he didn't write it. And so most of you have a tag on there saying that it's not by Frederick P. Schaefer. I have a carton of these in my office. If anybody else would like extra copies, I'm delighted to share them. Frederick P. Schaefer, who is the general counsel of the City University of New York, did write a more technical analysis that I didn't share with you, but I'm told that both of these documents will be posted on your website along with the tape of this session. So if you'd like a hard copy of the more technical document, I've given one to Joel and one to Suresh. I can send one to others, but you will have it electronically. And let me pause now for questions again before we start on our case studies, which I hope will generate additional questions and dialogue. But does anybody have a point for clarification now? Or
I'll offer a couple of brief comments. Number one, I've tangled with Mr. Schaefer. He's general counsel of the City University of New York. I chaired the Committee of AEP Investigation and Determination of Mohammed Yusri, who unfortunately was later convicted of treason, shall I say, serving his time in federal pen on really outrageous charges. He was the translator for Lynn Stewart, who was prosecuted for relaying words from Sheikh Omar to his followers in Egypt. You may have followed this case. He was the translator. And what he did, certified by the Prison Bureau and the FBI, simply translate for her, but he was held to have facilitated these acts of supporting, aiding, or abetting a terrorist organization. In any event, he was arrested and summarily removed from the classroom by the City University Central Administration. And that summary removal of him from the classroom was defended by Mr. Schaefer. And I dealt with him across the table. It was one of the more unpleasant experiences in dealing with the university council, because he thought it was absolutely right. That the university was privileged to remove someone from the classroom because of the public relations liability that person posed, particularly in New York Terrorist Act, and I need to fill in the details. It was not, however, I hasten to add, an academic freedom case. It was a question of simple due process and fairness. And there's a sentence I caught me in Mr. Schaefer's document where he talks about faculty organizations, namely the AEP, defending faculty rights willy-nilly, without regard to, well, that's the position of the City University of New York, that faculty rights, fairness, and due process have to yield when there's a larger public outcry, or potential outcry. There was not in that case, actually. Usually was buried on page 1 column, page 32. Having said that, I do think that the sort of tour d'horizon of threats to academic freedom, external and internal, has been very useful. We can talk later, perhaps, about the role of IRBs, which is most understudied in terms of, and I am chary of any group, even if it is a collegial group, vetting, exercising prior restraint on the ability, for example, to conduct an interview. It's not obvious to me that the medical model should have any purchase in that situation at all. As our institutions become more and more impecunious, and you never have enough money, the relationship to industry is going to pose increasing problems of conflicts of interest. And that does require, I think, very intense institutional scrutiny. And even though the Horowitz crowd was sort of knee-jerk Bill of Rights, and I mean, it was an outrageous thing, the idea that the courts would now supervise curriculum decisions and teaching, the natural consequence of these statutes, which you refuse right now. No state has passed those statutes. So that blunderbuss effort to reshape, to bludgeon, particularly the faculties in social sciences and humanities, in their teaching, that's ended. What is not ended, and I don't know if you've seen this, but I've seen it certainly elsewhere in my campus, is efforts by groups to fund donor-directed foundations housed within the institution, but over which the institution exercises no control. These are they are 501c.
Three.
No, they're not C3.
Oh.
There's a separate category for donor-directedness. And so they claim the imprimatur of, let's say, the University of Illinois. We are the Academy on Limited Government and Free Enterprise of the University of Illinois. But we are of the university, they're in the university, they're not of it, because the university has no control. The donors control where the money will go, and are accountable only to themselves in that regard. The New York Times ran a story that this was a much more subtle, second-tier effort by external groups. I don't care whether it's the right or the left. It's a fundamental invasion of the principle of institutional autonomy, of the freedom of the institution to decide how its resources Faculty members can apply for research money as they will. If they want to apply to the Socialist Party, if it exists anymore, they're free to do so. It's an infringement of academic freedom to say that we're going to place a limit on how your own research gets funded. It's quite another matter to say that there's an entity of the university controlled by the donors to that fund alone that will decide what to fund certain courses, programs, conferences, and production of papers. You get a sort of American Enterprise or Institute or Cato Institute housed within the institution over which the institution has no control. And they're proliferating. And I haven't seen anything systematic getting its mitts on that, and I think that too is something that we have to keep an eye on that.
And Matt, you were saying recently that on the other side, the accrediting bodies may be taking renewed interest in academic freedom because most, if not all, of the regional accreditors have academic freedom as an expectation for institutions. And at the back of the primer, we quote the Middle States accrediting standard as an example. And do you want to comment on that? Are the accreditors positioned to do some advocacy, some inquiry on these issues?
I don't know.
Okay.
There is a subcommittee of the accrediting of the overarching the private organization that accredits creditors, who watches, what custodian watches. And the AEP, they're meeting on Tuesday next to see if they can have something sensible to say that will encourage accrediting agencies. Accrediting agencies are happy or maybe not so happy to have cordial language in their standards. They will not process cases, and I don't blame them for that. They're not equipped to handle complaints and cases. But in very notorious situations of an obvious breach, they tend to be silent. Why? And shouldn't accrediting agencies, if they believe that the atmosphere of freedom within the institution says something about the quality of the institution? The example I gave is I won't name the institution because I can't remember it, but it's a Southern institution where the administration by UK's announced a policy that too many it's one of the smaller benighted historically black institutions. The catchment students that come in are underprepared, put mildly, for collegiate education. Too many were failing. And so the administration said, well, it had a graduated scale that if a student is earnest and shows up for class, automatically that student should pass. And it's the grades above that. Well, in biology, 2 professors of biology administered that policy for, my recollection is 2 years. And finally said, enough is enough. We have students who are earnest and show up, but have not gotten a passing grade on a single quiz or examination, and we're giving them C's. And we simply will not abide by that now. The giving of a grade as in the fair, impartial, and exercise of professional judgment is, I would argue, an act of academic freedom. By the way, the courts disagree with that. The grades of the institution's grade. But I think the profession would say that the faculty member's grade, which the institution adopts and endorses. Right? And then most institutions have rigorous grading committees to check obvious arbitrary abuse. Not the point. These 2 professors were fired for refusal to abide by a policy that they thought was professionally disreputable. I wrote to the chair of the Higher Education Commission, Southern System, saying, look, this has now been documented. If you think the AEP was wrong, it's gotten its facts wrong, by all means invite the administration to share information, not share publicly otherwise. But if the facts are as they are, does this not say something to you about whether this institution is an institution of such probity or indeed quality that it ought to be retained as an accredited degree-granting institution? And the accrediting agency's response to me was really Solomonic. It didn't answer at all. That's one way to deal with it. I do think there's a role for accreditation. Accrediting agencies, let me put the larger picture because it is part of it. I've been beleaguered, I don't know about this administration, but certainly by the Bush administration, more and more to become extensions of federal policy. And they have resisted that as a bulwark for respecting institutional autonomy. They are not simply the handmaidens of a federal executory will to have assessment measures and outcomes as an element of institutional regulation. Now, it may be that their desire now to consider a closer embrace of academic freedom falls into that larger mosaic of a defense of themselves against federal regulation. That may be part of the picture, which, by the way, I endorse. I think that that's quite right. I think the accrediting agencies is altogether too defensive in holding the federal government at bay. They're not extensions of the federal government. They should be considered as such. But that gets us into a different conversation.
And I think we have a question here and one in the back. Yes, sir.
A couple of years ago on Committee on Research at the university, the proposition came up to restrict acceptance of grants from tobacco companies. I don't remember how that was resolved, but it was hotly debated. And we were saying that faculty members should have the right to accept grants from whoever gives them. However, there was a considerable effort by faculty, well, Patrick, you know who, pushing for restricting acceptance of those such grants. I wonder if you could comment on that type of...
The EA said, no, it said that if an institution adopted such a restriction would violate academic freedom. It had earlier ruled with respect to applications to a grant from, was that the University of Delaware? From a foundation that was notorious in support of eugenics. But the position of Committee A was it was irrelevant. Where you see, so by the way, I think professional ethics would require any publication to indicate the sponsorship is public. But what was?
Well, that did emanate from my campus. And at the time, I was the divisional chair of the Committee on Academic Freedom, and we had a forum on this topic in prelude to a faculty vote at our division on whether there should be not allow faculty to accept money from the tobacco company. So we had plenty of people to speak at the forum for the policy, and actually I found a gentleman by the name of Sidney Brenner who agreed to come and speak ostensibly for the policy, but he wasn't really advocating greatly for it, but his basic point was it really shouldn't matter where the money comes from as long as the research is good. Ironically, 2 weeks later, he won the Nobel Prize. So there was some vindication, I guess, to his standpoint. But anyway, our faculty voted on it, and the vote on the campus, because everybody was allowed to vote who had a faculty appointment, was for the restriction. But the vote that went to system-wide was the academic senate members who did not approve it. And so it didn't go forward from the faculty side. And I don't remember, does anybody here remember, did the other divisions vote on this? I think they must have.
I don't recall that we did.
Maybe not.
But UCORP did not support it.
Yeah, maybe the standing committees, because Academic Freedom was against it, UCORP was against it. But anyway, the individual who was pushing it went to a regent, and the regents issued RE 89, which was a policy statement to the campuses to say, okay, you can accept it, but there has to be a review of that faculty's research project locally prior to the money being able to be accepted, and that each campus was then required to report on an annual basis to the Office of the President any grants or contracts that a faculty member received that was funded by the tobacco industry. So it was kind of an end run.
That's the Solomonic
right.
splitting the thing in half, right?
And I think we had one question in the back.
Yeah, this is just a much more minor sort of point of clarification. Professor Fox said that the divisional and system-wide committees on academic freedom don't consider, by tradition, do not consider individual cases. That's actually certainly not a reflection of policy in the last few years. I'm chair of our divisional committee here, and we've had a number of individual cases that we have considered. Actually, last year we had a rather vexing case that's part of the prehistory of this event in a sense. And actually we the first thing I did was to talk to the members of UCAP and ask them how they felt about whether individual cases were considered, and they all unanimously said they did consider individual cases on their campus. On the system-wide UCAP, just the last meeting that we had, there was discussions of a number of cases, and some of them are probably soon to be in the newspapers, and some troubling cases about academic freedom, individual cases. I actually was looking at the bylaws of both the divisional and system-wide Senate, and actually, surprisingly, the bylaws of the system-wide University Committee on Academic Freedom lists as among the commonly discussed topics cases involving the freedom or reputation of individual faculty members. So the current charge of UCAP explicitly includes individual cases. The current charge of the divisional academic senate here includes studying and at its discretion reporting any conditions within or without the university which may affect the academic freedom of the members of the university. And we have been construing that as including individual cases, and I think that's, as I say, there's a consensus up and down the system on that right now. I'm not saying that that's always been the case, but I think currently that is the case.
Well, you know, it's always a very difficult thing to extricate an individual case from the conditions aspect of it. But because, you know, there's concepts, and you all may want to weigh in on this, like the institution having academic freedom and autonomy versus the faculty as a body having that freedom, and then the individual faculty. So I think in the reading of the bylaws, I don't know if they've changed the bylaws, but the last time I read them, they were pretty generic about conditions within or outside the university, and were silent on individual cases and the review of individual cases. However, the identification of conditions isn't going to happen outside of individual cases.
Right, I think that's right. You also mentioned privilege and tenure. Sort of our experience in this campus is privilege and tenure is a very procedurally, very legalistic process which really doesn't afford a nimble response to encroachment on academic freedom. And that's also the experience of other committees on academic freedom up and down the system, as I said, which will become pretty well known probably pretty soon. So.
Well, there was a case I think I alluded to earlier at UC Santa Barbara, where a sociology professor had introduced some into the course content, introduced some images from a website that was critical of the Israeli government occupation of Gaza, and two students went to the chancellor and complained about it. And we were talking about this last night. The issue of the procedures is very important, because what happened in this case is that generally the procedure will be that that issue goes to the department, to the chair of the department, and it's trying to be dealt with there. And then if it doesn't work out, then it goes up to the next level, which would be the divisional privilege and tenure. And the problem in this particular case is that it didn't follow those procedures, and so the lack of following the procedural guidelines as outlined in the APM was an issue which I think we need to be aware of at divisions to ensure that we do under, I'll use the concept, I don't know if I'm using it correctly, proper due process. That there are established procedures for the investigation of these kind of things, and they really do need to be followed. And unfortunately, you know, us faculty are probably more interested in doing our research than sitting on committees and trying to figure out what the policies of the university are. But it is important to ensure that we try to implement those as faithfully as we can and in the proper order, so that when there is an issue, you know, the person who is bringing it is given a fair shake in the appropriate kind of mechanisms that we have. But the point you're making is an excellent one. It was always something that I kind of felt like schizophrenic about, because the institution and its processes and the threats to the institution can really, not all the time, but many times are only identified through individual cases. And that's where I think it's important, like in the case example that I gave you of the faculty member who came to our divisional committee complaining about the protocol review that he received through the Cancer Center. You can kind of deal with the individual case through looking at the processes by which the faculty feels they have been aggrieved. And that's why I think sometimes there's parallel operations between the E&T and maybe in some cases academic freedom. However, it's important to note also that, and this is especially on my campus, since we're all health sciences, about half of our faculty are not members of the Academic Senate, and so are technically not allowed a P&T hearing. And that's a concern from an academic freedom standpoint.
I think I might turn to our case studies now. And will you push the magic button here? Great, thank you so much. We have put together some examples, and I'd like to say first that any resemblance to actual people or events from our case studies is entirely coincidental. These are fictional case studies, so please don't take them as it's done. And I present to you here a stoplight. You have cards, red, green, and yellow. I'm going to give you a case study, and then I'm going to ask you to reflect a moment and then hold up a green card if you think academic freedom protects the situation, a red card if academic freedom would not protect the situation, and a yellow card if you're on the fence, if you'd like more information, if you're not feeling decisive today, whatever. Your yellow cards are there for your use. So, and I'm hoping that we'll get some conversation going also as we go through these, not just on the case studies, but more generally. So first I bring you our engineering professor who repeatedly uses profanity in class. Now, let's get ready for a show of cards. A green card if you think this is okay, a yellow card if you're uncertain, and a red card if you think academic freedom would not protect this. And I give acknowledgement to our team of engineering who is housing this terrific event. All right, show of cards. I see mostly red cards, and then I see a few yellow cards. Can I ask you why you hoisted a yellow card there?
If you'd asked me a few years ago, I would have said red. But having dealt with not necessarily engineering professors, it's yellow.
Because? What?
Because there's always a need for more information. One sentence is usually not enough to say whether it's red or green.
And what kind of information might tilt you red or green, if I can just dwell on this a moment?
Again, harder to say with engineering as the but if it was just a professor using profanity, it may depend on the content of the class and whether there truly was some even if vague reason why it was important in the course.
And if the professor were cursing at the technical equipment that never worked in the classroom,
guilty as charged.
Right. That would be a different case than a professor who is lecturing to students and interacting with students with profane language. Okay. Comment in the back.
I was actually going to ask a question about this a little bit earlier, especially because there's some sort of sniggering when people talk about anthropologists in there. But insofar as actual subject matter of research, which may be in fact the subject matter of the course, is a topic that may be, for example, something that's illegal, like immigration in the United States, or that's offensive, like swearing, being impolite, and so on. I can quite imagine that I, as an anthropologist, would in fact do teach a course on politeness and respect, And the flip side of that is influence and disrespect. And actually I find that it's at least conceivable that there are, just to touch on another matter that's also been mentioned about intra-institutional potential inconsistencies here. I think there actually is some real conflict between these, which I would consider to be legitimate topics of my own work as an anthropologist, and IRB restrictions, our ethics training programs, anti-harassment policies in the university. I think it's actually much more difficult than one might imagine to resolve this.
Yes, and let's move to our. Oh, yes.
Yeah, so I'm instructed actually by Matt's definition that accepted professional standards. Academic freedom, yeah, you can say as you believe it, but if the profession, in this case, I assume most engineers would not want cursing in the classroom. I use that as the primary motivation to say, no, this is not acceptable. But I wanted to get a sense of what Matt has to say about that.
Well, I think our anthropologists hit it head on. If it serves a valid pedagogical purpose, then it's within the pale. If it's gratuitous, or certainly if it's directed at particular people, that would be downright unprofessional. That would be grounds for institutional sanction, harassing students, calling them names.
But it is precisely for this reason that there's some potential ambiguity. So just to give a very simple and real example, I frequently have tried in the past, before coming to UCSD, to teach about the concept of blasphemy and profanity by showing a little clip. In fact, I usually don't show the film, but I show the trailer for a movie that I expect most of you know. If you don't know it, you should see it, called The Aristocrats. Extraordinarily funny movie, but it's entirely, it has no sex and violence, but it's probably the most vulgar movie you'll ever hear or see. It's about a dirty joke, basically. And I was actually instructed by my colleagues when I came to UCSD not to do that in my classes here, precisely because it was likely to offend the religious sensibilities of a large proportion of the students in my class. So it meant that I had to find some other way to make the same point, but it's not so easy to do.
And so you made a pedagogical decision. It was not so much fear of your personal security in your position, but to adjust to the diversity of the student body, the differences in the student body here as opposed to where you might have been teaching before.
Reluctantly, yes.
Yes, okay, so it's a kind of self-censorship.
Yes, it is.
Okay.
But I can understand, well, it was Mark Twain who said of freedom of speech, the Constitution gave the American people the right to free speech, and they had the good sense not to use it. But that's a judgment for you to make. The fact that a student is offended or that a group may be offended should be neither here nor there. I mean, if there are students who believe in the geocentric theory of the solar system, or and if you tell them that that's wrong, they're likely to find. I mean, you're cutting to the very core values, the depth of their religious belief, and you can be respectful of the student. I understand this is part of your Beltran challenge your religion. I'm not attacking your religion, which is neither here nor there in terms of discourse. I'm telling you that the earth really does revolve around the sun. Unless you can give me non-religious reasons for believing it to be so, I'm holding you to account to that. The fact that the fact that a student is offended is, as I said, neither here nor there. If you're challenging some of the most deeply held beliefs that students will have, then you're doing your job. And it's the most effective way to do it. How do you bowlerize a course on offensiveness? So I understand why you did it, but if you had been pulled up short for having done so, I certainly would be one of the first to defend your right to do it.
And our next case study is our social work professor who is role-playing a client who is using profanity in a class discussion. Cards, unanimous on green cards here. And that one is is an easy one. So you can't make bald statements about don't use profanity in class for the reasons that we discussed. All right, here we have our theater student who is a Mormon who refuses to recite lines from a play that contain profanity. And we're raising the issue of student academic freedom. It's an assigned play, regular part of the curriculum. She says, I'm not doing it for religious reasons. Now, do her religious reasons trump the pedagogical decisions of the professor? So does academic freedom protect this student? I want green cards if you think the student is on solid ground, red cards if you think the professor would be on solid ground in requiring this, and yellow cards if you're in the middle. Okay, we have a good mix, almost a third of each. Would you like to defend the red side here?
So the professor has a right to assign, I think I held the right card up. The professor has the right to assign a student to do something in the course of the study.
Mm-hmm.
So the student should comply. Mm-hmm. And I don't think the student has the same academic freedom that the professor has.
The student has academic freedom, but you would say it's subordinate to the professor's right to control the curriculum. And this is a good segue from Matt's comment. You almost answered this hypothetical. What would, how do you come out on this one, Matt?
Well, this isn't her academic freedom. She's asserting a religious objection.
Yes,
The question
forgive me.
is whether the instructor is directing a play. The instructor picks a play with lots of profanity. Anything by David Mamet. Now, she signs up to play a role. She says, yeah, but I won't say these words because it offends my religious sensibility. Does the instructor have to accommodate that religious?
Right.
That's a real case. She's talking about a real case. There's another one. I don't know if you've seen the social work student who has a religious belief, believes that homosexuality is a sin and is condemned by God and so on. And as part of her social work preparation, she must counsel gay or bisexual clients. And she takes the position, well, if I have such a person, I would, of course, counsel them that their lifestyle is repugnant to God and they have to change. They go, no, we don't do that in social work. Well, in which case, I would refer them to someone else. Well, you may be working in an agency where you are the only social worker. We expect you to be able to counsel that person by our professional standards. And she says, I'm sorry, I cannot abide by your professional standards because they offend my religious beliefs. Now, that's the mise en scène. How did you solve it?
Well, in that case, the court decision details a very careful analysis that the faculty did, looking to the social work ethical standards, looking to the expectations of students in the discipline, working in the field. They really went through the analysis, a thorough analysis, rather than just knee-jerk saying, oh, you have to counsel gay students, whatever your religious beliefs are. They grounded it in professional standards and in their academic responsibilities and exonerated the institution. The faculty, the student was not successful in that case. Let's see, did we have another hand up, a comment, or should we move along to our next case study? We have a professor cursing out the departmental assistant for screwing something up. And imagine your own invent the blue streak in your own mind. Anybody want to defend this professor? Anybody yellow or green on this one? No, okay. Excellent. All right, well now move off profanity and into the statement, all female students are whores. I'm probably getting too close to that microphone. Okay, and our first person who makes this statement, as you see, is a professor who is counseling a male student, advising a male student about his course selections. So the professor says, all female students are whores. Does the professor have academic freedom in that context? give me your yellow, orange, your cards. Okay. We're mostly red. A couple yellows. Would you comment on that one?
I have no idea why this could be relevant to course selection, so that's why I'm asking for more information. I can't imagine what would generate that statement. And so maybe there's some very peculiar reason why this is an academic issue, but otherwise it sounds completely irrelevant.
Yes. Yes, I agree. And I think the only kind of thing that would tip the balance for me would be if the professor were saying, well, maybe you think all female students are whores, and therefore you don't want to take a nursing class, or, there's some very weird examples that might justify this, but the fact here that the statement is made to a male student doesn't really affect the hypothetical in my mind. Okay.
But I have to say that I grew up south of Paris in the 50s, and I was told the École des Beaux-Arts was the biggest whorehouse in Paris. So this resonates against my
All right, now, do you have a comment on the last one? Yeah, please.
The question on the last one, so you picked an extreme example, but what if the professor was talking to a student and said, there's no point in training women to be PhD engineers because they're just going to get pregnant and quit. And that's my opinion. And so I'm counseling you, female student, don't bother to go into a PhD program or apply for a PhD program because you're just going to get pregnant and quit, and we're going to waste all our money. So there, how would you analyze that one?
And I'd take your hypothetical a step further. If the professor were counseling a male student saying, all those females are going to fall by the wayside, you'll have the best career because you'll shoot to the top. So it isn't immediately made to a female, but the sentiment is still the same. I would say the institution has a non-discrimination policy. The professor has an ethical obligation to respect the rights of students. And while that may be his or her personal belief, and Saturday and Sunday, if they sit around home and write to the newspaper on that theory, well, that's a different case. We'll get to that one in a minute. But I think academic freedom would not protect that statement because it is so at odds with the values of the profession, the values and policies of the university.
What if this defense is true? It may be at odds with your values, but I think it's true.
Well, it's not true for every woman. And so we were talking last night also about a case where a professor said, all Indian students are plagiarists. I've done research in India and plagiarism is endemic, and so in my classroom here in the United States, I just warn all of you, half the class is Indian, and so you are plagiarists and I don't want it in my class. There, I would say my own view is that does not take into account the audience. You may have surveyed in India. I doubt whether you found 100% plagiarism, but in any case, you're in a different setting here where your students have had different cultural experiences and they may not be 100% plagiarists. And so this is also a kind of group defamation. And there's a trick here. What is a balance, I should say, what is within disciplinary competence and what is not. And I think to condemn all women as they're just going to get pregnant and married and not pursue their careers ignores the fact that there are many women who disprove that supposed truism. So, okay, go for it now.
Not the first, but the second example. I mean, should it make a difference that it was in back and forth in a private conversation, or even a sudden expostulation in the course of a class, an extemporaneous comment, as opposed to something as actually in the case that I gave, it's a real case, it's in front of my committee now, where it was videotaped, and the question was, it was persistent and insistent. Also, there is a question of breathing room that you have to allow a lot of, I think, play and enjoyance for what people say to one another. And there's a pretty thin line between the medium and the message, how something is said. If she had said, well, I said we have this experience with Chinese students, that the submission of research papers without attribution in law is quite, I would say, is common, not anecdotally, right, in my school and others that I've spoken to. Now, would I say to our Chinese students, we have 100, you Chinese have no understanding of plagiarism, it's endemic to your society, something in your culture, I think that's offensive, counterproductive. But what if I said, I understand that it is a sign of respect in certain Asian societies to refer to well-known texts without attribution simply because they're so well known that it is an honorific to the person quoted, which is actually true of certain Confucian texts and Buddhist texts. But in the United States, our tradition requires a rather meticulous, perhaps excessive, but nevertheless required documentation of all references. Now, I'm really saying, the point I'm trying to make is say, how it is said makes all the difference. And I think we do have to allow instructors at least a little bit of breathing room in the spur of the moment for how they communicate. That's quite different from a persistent intrusion as a part of a prepared lecture or program. But those are the fact-specific kinds of things that our committees.
Right, exactly. Keeps a lot of people busy. I would add that the AAUP statement on professional ethics calls on professors to be effective teachers, to show respect for students, to assert their proper role, proper being undefined, as intellectual guides and counselors, to avoid exploitation of students, and to respect students' academic freedom. So these can be analyses of ethical responsibilities as well as academic freedom rights. And now we have a law professor who is asserting the all female students are whores as a class example of group defamation. Everybody comfortable with that one? Any reds or yellows here? Okay. It's like our social work professor. Right. And then we have our invited speaker who's using the statement in the course of a discussion on academic freedom. I hope that one's okay. Now we move to a fraternity that's displaying a sign with this same statement as they're tabling on the main walkway of the campus. Would academic freedom protect this? We've got green, orange, red. Academic freedom as protecting this. Let's have a show of cards. Okay, we have mostly reds, a yellow, or two. Now, that was a trick question because I was asking you about academic freedom. And this is not an academic pursuit. It's occurring on a campus. Yes, these are students, but it's not an academic freedom issue. You would find the answer to this at a public university in the First Amendment and also in the student handbook, student rights and responsibilities. And at a private university, you would find the answer in the student handbook, the student rights and responsibilities. Would either of my colleagues care to comment on this?
I would agree that this is not academic freedom. It is related to the student handbook for appropriate conduct while at the university. That's what I would
The problem is this. That when the American academic profession created its theory of academic freedom. It borrowed on the term itself, borrowed from German usage, which was by then 100 years old itself, Akademische Freiheit. Akademische Freiheit had two components. Lehrfreiheit und Lernfreiheit. Lehrfreiheit, the freedom of teaching, was the professor's freedom. And within the confines of the obedience owed by a high civil servant, which dropped out of the American theory, it was quite all-encompassing. We weren't concerned. Arthur Lovejoy and that bunch were simply not concerned with Lernfreiheit, the freedom to learn, student academic freedom. In part because our institutions in those days were under the doctrine of in loco parentis. The institution was the substitute parent, and the student was a child in tutelage. We never had to think about it. Well, in the 1960s, we had student rebellion, and most institutions abjured the notion that they were any longer the substitute parents. However, there's a very strong residual of that still, and maybe we were discussing it earlier, the courts get involved, but what the institutions are. I think if you're an adult, you're an adult, treat you like that. No, we can't, you're not really an adult. You can vote for drink. No. The institution retains some kind of residual response. I get ill-defined. So we have no defined concept of what a student's academic freedom. Now you're talking about the extracurriculum. And as I understand, and I'm not an educational psychologist, but I've done a little bit of reading, a little bit of knowledge is a dangerous thing. I live dangerously. That a lot of education goes on outside the classroom, in the extracurriculum, of which this fraternity, I was blackballed, the only fraternity I ever tried to join. Absolutely right decision. But I take it these institutions are somehow part of the social fabric of the institution. You're quite right. It would be analyzed from the First Amendment point. Can the institution sanction this display? But I'm not getting into that. My only point is that it raises a whole bundle of issues. Questions about the status of the student and the role of sodalities, student sodalities in the extracurriculum. How much regulation can an institution or must an institution impose? That's absolutely unresolved. There's a doctoral dissertation there somewhere.
And there are legions of court cases on the issue as well. Yeah. And on that note, I think we've reached the end of our appointed time. And I think we'd be happy to take any additional questions up at the front. And so, Joel, may I thank the group and...
You thank yourself.
All right.
I should stand up.